Commonwealth government officers and others.
Sir James.
Well, good morning. You have the press release which tells you who is representing which party, so I hope I don't need to go through that.
Good.
And I will take that as read if I may. I was going to pitch straight in. And just to make some short comments by way of introduction to the factual position that confronts you in this appeal. The allegation against the defendants in this case is of alleged complicity in the claimant's mistreatment through the passing of questions, it is alleged, to the American authorities, the CIA, who were, it is alleged, holding him. It was the US who are said to have mistreated and or tortured this individual, and it was that mistreatment or torture that is said to have caused the damage here, namely the personal injury that is claimed by the claimant. The parties have proceeded on the basis that if questions were passed, the relevant UK officers who passed them were located in the UK when they sent the questions. And I should make it entirely clear at this stage that the appeal comes to you in effect as an appeal from a preliminary issue, and the parties to the appeal have proceeded on the basis of an assumption that the facts pleaded in the amended claim form are correct. I won't, I hope, keep boring you by putting the word allegedly in. But if I make statements that sound like they're statements of fact, they are assumptions at this stage, no findings having been made. That might be quite important because, as you're also aware, and it's an issue to which I will return, the defendants, as is very common nowadays in this sort of case, have adopted, in open at least, a neither confirm nor deny stance, an NCND stance, in relation to any allegations that might raise national security concerns. So I will address the facts as if they were facts, but subject to that being clear to all who are listening. Notably on that basis and on the assumptions that the statements that are made in the claim form are correct, even on that basis it is to be noted that the defendants are not alleged to have played any part in the claimant's capture, to have played any part in the claimant's rendition, to have played any part in the claimant's detention, to have been present at or physically participated in the treatment inflicted on the claimant, to have had any direct contact at all with the claimant, or to have been aware of the claimant's precise location at any time during the relevant period, which was 2002 to 2006. The allegation is that for that period he was detained at a succession of what are described as black sites, the locations of which were not known to the defendants. Furthermore, you will have noted, the claimant is not a British citizen, has never had any form of leave to remain or permission to enter the United Kingdom, and as far as we're aware, has never been in the United Kingdom. So the only factors linking this case with the United Kingdom are that the allegations of tortious conduct are levelled at UK public authorities, and the parties are proceeding, as I've said, on the assumed basis that the relevant officers of those public authorities were in the UK when transmitting the questions to the CIA. We invite you to note that the fact that the allegations are made against UK public authorities is, of course, wholly unexceptional. It's a bare minimum, and without it there'd be no basis to sue in the UK at all. It provides no real assistance, we will submit, in determining the applicable law, which is what this appeal is about, and whether this is one of those very rare cases where the general rule provided for in the relevant legislative scheme will be displaced. In reality, on the facts, the only identifiable factor beyond that is the assumed presence of those officers in this jurisdiction when they are asked the questions. I wanted to add just two brief things in relation to the facts. Firstly, and very shortly, there is some reliance by the claimants on the judgments of the European Court in Strasbourg in cases involving this claimant against other states, and of the report of the US Senate Committee, our submission is that those do not assist this court for present purposes. They were simply not concerned either with the issue which confronts you or indeed more generally with a claim against these defendants. The second point I wanted to touch on briefly...
Don't assist in relation to what?
They don't assist in relation to the issues which you have to decide, which is applicable law.
In relation to what specific issue do they not assist?
They don't assist in determining whether or not the statutory tests provided for in Section 11, the general rule that it provides for, and then the balancing exercise.
Is there any difference between the decisions of the European Court of Human Rights and the assumed facts upon which we're to proceed?
Well, I think the answer to that question is that the European Court's judgments do not address the same territory as the points of claim which are the subject of the assumed facts.
That he was...
You're to assume that he was held in black sites and so on.
Sites.
You are.
Yeah.
But they deal with claims against, they deal with claims against specific countries.
Yeah.
But they extend more broadly than that and more specifically than that, is perhaps the point.
Yeah.
So, I mean, they assist to some degree, but assumptions are being made anyway.
Yeah.
And if we get to trial and there are fights about...
You're not challenging those assumptions.
I'm not challenging those assumptions now. No. If we get to trial and there's a fight about some of them, then it may well be that we'll have to take on some of the facts that the European Court identify. But even then, I suspect my submission would be that they are irrelevant, and it's for the English court to determine what the facts are. The second point I wanted to raise was Article 9 of the Bill of Rights. You've seen some fleeting reference to that in the cases. That arises in relation to some reliance, particularly past reliance, but there's some continuing reliance, as I will indicate, on the Intelligence and Security Committee of the House of Commons report. And that's included in the Respondent's bundle, having been the subject of an objection by us to its inclusion. I don't want to take up a lot of time on that. If there is controversy about it in relation to this appeal, it arises principally and perhaps unpromisingly in relation to footnote 2 to the Respondent's case, that's the other side's case, page 80 of the electronic bundle. If I give you page numbers into the electronic bundle, they're all into the core bundle. So footnote 2 is the only thing that is controversial. And there appears there to be at least an implicit invitation to the Supreme Court to rely on that report. My submission briefly is that footnote 2 is subject to the same objections that arose in relation to the myriad original references to the ISC report in the particulars of claim. That is, it relies on the content of the ISC report as true for the substance of what the claimants assert. And that's a problematic thing to do because it would be to call into question proceedings in Parliament, is our case. Our position throughout has been that such an approach would therefore amount to a breach of Article 9 of the Bill of Rights. That, we note, has also been the consistent position of the OSC, the Office of Parliamentary Counsel, as it were, and she submitted, counsel on her behalf, submitted submissions, put in submissions to the courts below on that Article 9 issue. They're not in the bundle. They can be provided if the court wishes to see them, but they were, in effect, supportive of the position that we took, that sort of reliance upon that committee report would be a problem under Article 9.
I'm not quite sure why all of this matters. Don't we just go on the pleaded case?
My Lord, I think you do, which is why I'm not going to spend long on it. I wanted to put down the marker, however, because there had been a great big battle below about whether or not reliance upon that report was permissible, and those would be the facts that everyone would be assuming in the pleading. Ultimately, the position that the claimants took was that sort of report didn't fall within the scope of Article 9 of the Bill of Rights, because this parliamentary committee had, as it were, its original source and power from the Justice and Security Act, having previously been set up by the 1994 Intelligence Services Act. And the issue effectively rather drifted away because ultimately all those references and the particulars of claim, which would otherwise have formed the basis for an assumption, of their truth for present purposes were taken out by the claimants. So the only significance is to put down the marker that says you can't adopt that position and then, as it were, reintroduce things in footnote 2, to the extent that it matters. But I fully take
as matters stand at the moment, Sir James, it's not a live issue before us.
It's not a live issue before us, and I don't invite you to determine it, and I'm not sure it's going to be necessary to rely upon footnote 2 anyway. I simply put down the marker that you can't adopt one position and then kind of reintroduce the same problem through a footnote in your case.
Well, if that position changes, we'll need to hear all parties in relation to it.
And we haven't addressed that. I simply put down the marker rather than making a fuss about it now.
In footnote 2, I mean, is there anything there that contradicts the assumed facts, is different from the assumed facts? That is that the black sites were secret detention facilities around the world outside the US legal system.
My Lord, no, that is an allegation.
Yeah.
I'm not taking a point of substance here. I'm simply putting down the marker that we don't accept that that's permissible reliance, even at this stage. They can rely on their pleadings. The assumption is that the pleadings are true, and we move on. I simply put down the marker. I wanted to turn then to the law, if I may, to the law and the statutory scheme, first of all. And the structure of the statutory regime is, we submit, of some significance here. It operates in 2 stages, as you know. The law, the statutory scheme is in the Private International Law Miscellaneous Provisions Act, 1995, and the relevant or key provisions are sections 11 and 12. See, if you would, in your electronic bundle, page 423. There is first, as you're well aware, I'm sure, the general rule in section 11. And secondly, there is the possible displacement of the general rule in section 12. And so the statutory analysis therefore starts with section 11. And so far as section 11 is concerned, the general rule in section 11.1, as you see, is that the applicable law is the law of the country in which the events constituting the tort or delict in question occur. So you need to focus under 11.1 on the location of the events constituting the tort. And we note in brackets all of them limited only to one aspect of the tort. Then in section 11.2, Parliament has made specific provision for the situation where elements of the events in question occur in different countries. And again, the focus is on all of the elements, not just some of them. Section 11.2, as you see, then deals with 3 different categories of claim. In A, B, and C, the key one for present purposes is A. So A deals with personal injury or death as a claim, B is property claim, and C is any other case. So Parliament has not only identified a general starting point, but has also specifically identified the approach applicable to a case like the present, where the events constituting the tort are not limited to a single country. This is not, therefore, a case in which the general rule applied by the statutory scheme fails to cater for the particular situation that has arisen. On the contrary, Parliament, in establishing the regime for determining the applicable law in cases which involve different elements occurring in different places, has made specific and explicit provision. And that is the position here. So the particular sub-rule, as I indicated, for personal injury cases is that in 11.2a, and the general rule prescribes that the applicable law in that situation, that sort of case, should be the law of the country where the individual was when he sustained the injury. The focus, therefore, is on the location of the claimant where he sustains the injury. That is what Parliament has deemed to be the appropriate general rule, and it is that general rule which falls to be displaced, if at all, by the application of section 12. In this case, of course, the claimant does not claim that he sustained any injury here. Indeed, it's no part of his case that he was ever here. So the general rule is that the applicable law should be the law of the 6 countries, not of the not of England, not of the UK. That's the statutory general rule, and on that basis one arrives at section 12. Two introductory points about that provision, perhaps. Firstly, the exercise, as you will see...
Before moving on from
Yes.
section 11, how does that apply in relation to false imprisonment?
My Lord, I suspect that the answer to that would be that the false imprisonment tort, for which damage is not an essential element, the applicable law under these general rule provisions would be the law where he was in fact detained. But it would probably fall within C.
Within C.
I suspect it would be within C.
Yeah.
You've got to do a general rule analysis first, but
There hasn't been a separate analysis of all the individual torts in this case. They've all assumed to be similar and stand together. Is that correct? I mean, is that the correct, approach?
I think it probably is correct, and you'll have seen the note, I hope, that we put in overnight with the elements of the various torts.
No.
All right, well, can I come to that? Because it seemed to me, at least, that we've done some of that in paragraph 38 of our case, and it may be quite important, at least, to have the basic elements of the tort set out. And what you will see from that note when we get to it, if we may, can I pick it up when I get to it? But what you will see from that is that all of the torts, apart from false imprisonment, are torts in relation to which damage is an essential element. So negligence and all the other ones.
Well, except trespass to the person, including false imprisonment.
Exactly so.
Yeah. They're all
Which
actionable.
is the subject of my Lord Stephen's question.
They're all actionable on proof of damage, except trespass to the person, which is actionable per se.
Exactly so.
Yeah.
And
Just following that. Well, I mean, we could do with the note, couldn't we? Really?
Yes. Well, my Lord, I'm so sorry you haven't got it. We've got hard copies here. It's rather irritating to me.
Well, that'll be very helpful. So, James, it does appear that so far in these proceedings, it's been common ground that the 5 torts identified should stand or fall together.
Yes.
And we may have to unpick that.
You may have to unpick that because there are elements, as my Lord has identified, which are not dependent upon proof of damage. I suspect that my submission will be that the answer is probably going to be the same. You're going to need to do the general rule in relation to the tort which is actionable per se, but the natural location for that, as it were, if you applied 11(1) or 2C, would be the place where the detention actually occurred.
Can I just ask you about that?
Yes.
So let's just assume for one moment that we are talking about trespass to the person and trespass to the person which has caused personal injury.
Yes.
So we've got a situation of battery or assault or false imprisonment, which has then led to, or consequent on that, there has been personal injury. Would you not read for a cause of action in respect of personal injury as including that situation?
My Lord, that was a thought that occurred. I suspect the answer to it is that you would, because the critical words in 11(2)A would be for a cause of action in respect of personal injury. And that's probably broad enough to include a tort which is actionable per se without proof of that, where the essence of the thing was that, I mean, for example, you could have a situation where someone is detained and the allegation is, or there's a trespass to the person, the allegation is that that did in fact lead to, and the substance of the claim is that they suffered personal injury as a result. My submission is that that would be capable of falling within, and it would be natural for it to fall within 11(1)A. But if you don't do that, you still would look at the place of detention under C.
May I ask 2 questions? First of all, you haven't said anything thus far about the state of mind that we're to assume for this purpose the defendants have, the appellants have.
Yeah.
That's one. And then the second is, how are we in circumstances that we're asked to assume for the purposes of this appeal to deal with where the damage may have occurred? Because if we're concerned with personal injury, which, as I understand it, we must assume has happened, can one ascertain where the personal injury of any particular kind was suffered and to what extent it was suffered in any particular jurisdiction?
My Lord, I think the answer to the latter question, if I can take that first, the answer to the latter question is, on any view, it's not the United Kingdom, because he was never here, he was never subjected to ill treatment here, and any of the damage that flowed as a result of treatment that he received elsewhere and or at the hands of another public authority, in this case the US authorities.
But in terms of the jurisdictions where that damage may have been suffered and consequently the law that may be applicable to that, how are we at this stage to ascertain or assess the difficulty with which that particular analysis could be carried out?
Well, my Lord, I'm not sure you can do much more at this stage than make an assumption and or an inference that the personal injury that is said to have occurred flowed from the mistreatment that is said to have occurred, and if that is so, the natural place at which at least the initial injury occurred will be the place where that mistreatment occurred.
But that might have been in one country or another country or perhaps a third country.
It might have been 2 or 3. It might have been.
I mean, the point is simply that all we know is that questions were asked, or assumed, sorry.
Yes.
All we assume is that questions were asked. We don't know which countries they were asked in, we don't know what injuries were inflicted in those countries. And so when one's looking at the broad evaluative exercise eventually under Section 12, how do you know which law to apply? Because you don't know where the injuries, the particular injuries, were sustained that came from those questions.
I fully take the point. There may be cumulative causes feeding into the nature of the injury ultimately suffered, and at this stage it may be uncertain precisely where the build-up of injury, if that's what it was, occurred. But one thing I would submit, if you put this as a point to me, as it were, under the general evaluation, the one point I can, I think, fairly make is that whatever else you do in relation to those difficulties, and I've given my answer as to how you should be proceeding on the basis that it flowed from the mistreatment at this stage at least, the one thing you can't do is to jump from that sort of difficulty into saying, so it must be a place where on no view did the injury occur. In other words, England. I mean, whatever else may be difficult about that, about this exercise, that isn't. I'm very conscious I haven't addressed Lord Kitchen's first question to me, which was about the state of mind of the defendant.
Before moving on, the test is substantially more appropriate, and if you don't know which applicable law to apply in relation to all the cumulative injuries sustained over a period of time from up to 2006, which law?
Well, my submission is that you apply the law of the place at which the injury was first sustained at the moment.
Were first sustained, or last sustained, or I mean, there are 6 countries here.
There are 6 countries here.
Yeah. So how do we know which injuries were sustained in which country?
Because at this stage, my Lord, it isn't a final analysis. The House of Lords or the Supreme Court in VTB made the point that if you're assessing things as a preliminary issue, then circumstances may change as the evidence clarifies. But at this stage, my submission to you is that the correct approach is to assume that the injury flows from the mistreatment which is alleged, and the mistreatment which is alleged happens in each of the 6 countries. So for present purposes, I'm not sure you are in a position to do more than that. But as I say, my overarching point is it would be extremely surprising, I submit, if the consequence of that, assume there were only 2 countries, and assume that the connection with the United Kingdom was even more minimal than simply the sending of the questions. What the court would have to do under the legislation is to grapple with that.
I mean, we have to assume, do we not, that there is damage in each of the 6 countries, because otherwise there's no tort being made out at all in most of these circumstances.
Yeah.
So it would seem to me that we have to assume, as I understand it, that there is personal injury suffered in each of the 6 countries. That must be an inference, I think, from the assumed facts, because otherwise
you don't have a tort.
We don't have a tort, unless it's been said that in relation to trespass to the person, there is some sort of claim merely for being detained, irrespective of any personal injury consequent on that, which I did not understand
that's not the
there
right
to be the allegation.
No.
So we have to assume, I think, personal injury in each of the 6 countries.
Well, I'm content with that. Or you can say, well, we assume that the injury flows from the mistreatment that occurs in each of them, and if that occurs in the 6 countries, or if that occurs in only one of them, as the evidence proves, well, so be it.
One assumes that fact, but then you then come to hit the brick wall of, in applying the law of that country, to what are the injuries that you apply it to? You assume that you apply it to injuries in a general sense, but to what injuries?
Well, my lord, if the allegation is, which depends what the allegation is, my understanding is that as a result of these matters, the defendant suffered, as I understand the claim, suffered either physical injury or trauma, as it were. And if it's trauma, it may be cumulative, it may be happening in each of them, if that's the allegation. And if it's trauma, it will more naturally flow from the place where the mistreatment occurred. That would be the obvious.
I mean, he could have been
conclusion.
Severely badly treated in one country and not so badly treated in another country.
He could, but if in either of them injury was caused, then he would have a claim for the physical injury that was caused as a result. If it's cumulative, then it may feed into both countries.
State of mind.
State of mind, well, that's what I was trying to get at.
Indifference or whatever. What assumptions are we to make for the purposes of this appeal as to the state of mind?
Well, my lord, I think the pleaded claim against us is that we either knew after a certain date that he was at black sites and or that mistreatment was occurring, or were reckless about that, or were indifferent to the places at which he was held. That's the pleaded claim against us.
And that he would be moved from site to site on this assumption, so as to ensure that he was being held outside the legal system.
Well, Mr. Hermer will have to answer that. I'm not sure it's quite as specific as that. There's just a general allegation that we either knew what was occurring to him in a general sense or were reckless in different justifications. I'm not sure I can help you much more with that. And that's the way the pleading is framed. Am I missing the purport of my Lord's question?
No, I think that's
But we can't assume that he's being moved to particular countries to evade laws applicable in the UK, let's say, or in the USA.
I don't think the allegation against us is as specific as that. That is the general allegation that is made against, in effect, the Americans. But that is, I don't think the allegation against us is as specific as that. There's just a general new, reckless and or indifferent as to location pleading.
But I do think we're going to have to look at the pleading at some time.
Yes.
Yeah.
I mean, so far as I can see, it's paragraph 26 of the amended points of claim, which I think is page 266, which says from at least May 2002, the defendants were aware that the claimant was being arbitrarily detained without trial at secret CIA black site detention and interrogation facilities and was being subjected to extreme mistreatment and torture during interrogations conducted by the CIA. Is that the only pleading of the defendant's state of mind? I may have missed other things. At all events, I don't want to take you out of your course, but
I think it's 26 is it, which is why I say it's a general allegation. Oh, I'm sorry, I should have referred you to that paragraph initially, but that I think is the core of the allegation.
Sorry, which page was that? I missed.
Page 266.
Thank you very much.
Paragraph 26. And, sorry, I'm reminded, and 47, worth having a look at while you're there. And that is on page 292. Yes, thank you.
yes.
And 48, perhaps.
And in terms of the inferences that are alleged in paragraph 28, on page 266, are we to assume, for the purpose of this appeal, that those inferences are fair ones to draw?
Well, I think you have to assume that. It follows from the nature of the exercise that we're doing.
Yes, thank you.
I haven't had an opportunity yet of reading this note in relation to the elements of the English torts,
Yes.
and no doubt it's going to be extremely helpful. One of the suggestions made is that the criminal law and the judicial review law, administrative law, would apply to the connection of the security services with England. It is illustrated by the fact that they are also subject to the criminal law and the administrative law of England and Wales. So I would be grateful for a note on what potential crimes would be committed.
Right. Well, we haven't got that yet for you, but of course that can be done if that would be of assistance.
And if that could be shared with the respondents.
My Lord, yes, of course. If that would help, you would appreciate that our case is that when you're dealing with tortious claims of this kind,
yes,
there is a primary legislative scheme which governs how you go about doing this exercise. Now, true it is that at some point you enter the calm lagoon-like waters of a general assessment under Section 12, yes. But that is a different exercise and a statutorily mandated exercise, which may raise very different features to the features that would apply when you're trying to determine whether criminal jurisdiction is established.
One of the factors relied upon is the connection of the security services with England and with the criminal law and the administrative law.
Yes, well, I'll come to that.
And so I would like precision to be brought to what the criminal law would be.
Yeah, very well. Well, I was at the moment just introducing Section 12, and I've made the first preliminary point in relation to that, which is that the exercise turns on a comparison between the factors, as it's put, connecting the tort, the significance of the factors connecting the tort with the country of the applicable law under the general rule and another country. And secondly, and it's an important point, and it was a point which was critical in the VTB litigation, which you will, I'm sure, be very well aware of, particularly my Lord Kitchen, who I think, right in saying, appeared in the Court of Appeal in relation to that case. But the comparison is not evenly weighted. This is not a simple balance under Section 12 between two sets of factors. It must be substantially more appropriate, is the wording used, substantially more appropriate for the other country's law to apply in order to displace the general rule that Parliament has seen fit to create in accordance with the provisions of Section 11. So it's a tilted balance with the scales weighted pretty heavily in favour of the general rule. And it might be thought that in that way Parliament has sought to protect the general rule from displacement in most cases. So far as the case law is concerned on sections 11 and 12, I suspect there's not a great deal of controversy about the basic approach that one sees from the case law. The leading case is the VTB capital case in the Court of Appeal and then in the Supreme Court. Again, I wasn't proposing to go back to that analysis for present purposes. You have most of it, if not all the relevant bits of it, in the judgment of Lord Clarke. It's behind tab 8 in the first of the authorities bundle, and the passages of particular relevance for present purposes are on page 773. 773, my Lord.
Thank you.
And again, I'm sure the court will have read this section, but the key and relevant section for present purposes runs really between paragraph 195 by the letter F on page 773. The second point is the question whether English law is the applicable law. You see that paragraph, and there is then a citation of sections 11 and 12 in paragraph 196. There is an analysis of how section 11.2c, which was the relevant one in that case, works in paragraph 198, where Lord Clarke effectively agreed with the Court of Appeal's approach in principle. They, of course, disagreed on the facts and the application of these tests, but they agreed the principles under 11.2c, as you see at paragraph 198, that they accepted that as correct in relation to 11.2c. You see from 4 or 5 lines into paragraph 199. And you'll see in the latter part of 199 a couple of additional points that the Supreme Court evidently agreed with in the Court of Appeal's analysis, including between C and D, that it was quintessentially for the judge to make an assessment of the significance of the elements of the events constituting the tort for the purposes of section 11.2c, and they wouldn't interfere unless they were satisfied that there was an error requiring them to make their own assessment. That's the appellate approach, therefore, at 199, second half. You will see at paragraph 200 that they concluded that section 11, I'm picking it up between E and F, halfway down paragraph 200.
I'm sorry, was that point about the appellate approach approved by the Supreme Court?
What is the Supreme Court decision?
He's reciting what happened in the Court of Appeal.
He's reciting what happened in the Court of Appeal, but I think when you get to the disagreement between the Supreme Court and the Court of Appeal, they are applying essentially the same approach.
So you say in substance they do approve it?
In substance they deal with the point and they apply the same approach.
Yes, all right, thank you.
And then you'll see the analysis in that case. What had effectively been alleged was the tort of deceit, as one sees from paragraph 201. And what the Supreme Court did, ultimately, was to focus on what they describe in 201 as the elements of the tort, unsurprisingly, given the statutory test. And they conclude that all of those occurred in England. So essentially the battle for the soul of the court in this case, and the substance of the disagreement between the Court of Appeal and the Supreme Court, was that the Supreme Court were focused much more directly on the key elements of the tort, whereas the Court of Appeal took a slightly more stand-back approach and effectively concluded that the plot had been hatched in Russia. And so that was essentially the source of the disagreement between the two courts. Supreme Court much more focused on the particular elements of the tort in question, the tort of deceit there, and as you see from 201, all of the key elements occurred in England, was their conclusion for the reasons they set out there. So that's section 11. Then they come to section 12 at paragraph 203. And they there set out 4 principles identified and applied by the Court of Appeal. To turn immediately to my Lord Sale's question in relation to that paragraph, we don't have a direct statement, I think, in relation to those principles that says we agree. So there's nothing comparable to the 5th line of paragraph 199 in relation to those principles in the Court of Appeal, but they are not demurred from, and they appear to have been applied as correct, at least in terms of principles that apply to dictate the general approach of the court. They appear to have been applied as correct by Lord Clark and the other members of the Supreme Court. The disagreement between the courts, as I say, was as to their application on the particular facts of the case in the manner that I've described. So 203 are the general approach principles for section 12. Lord Clark places some reliance on Dicey and Morris, unsurprisingly, in paragraph 204, bottom of page 776. I just invite you to read paragraph 204, if I may. That's the nature of the exercise that section 12 dictates. And then towards the end of 204 and into 205 and 206, they're dealing with my second introductory point, how you approach substantially more appropriate, that phrase, in section 12. But you get their analysis on that part of it in at 205. And perhaps the punchline of that is the final sentence of paragraph 205. The party seeking to displace the law which applies under section 11 must show a clear preponderance of factors declared relevant by section 12.2 which point to the law of another country. And then they emphasise in 206 both Lord Justice Waller in Rurig and Valiant Trawlers substantially as the key word. And also, and it's a section of the jurisprudence that we've cited in our case, the principles considered by Lord Justice Brooke in the Al Jeddah case at 103 to 104. I just invite you to read 205 and 206 if you would. And as I say, the passage from Lord Justice Brooke's analysis in 103 and 104, we've quoted in full 103 and 104 at paragraph 20 of our case. And if you want it in the raw, it's at page 461 of the electronic bundle. But we've cited it in full in our case at paragraph 20. But 461 to 2 of the authorities bundle is Lord Justice Brooke if you want it. But just to pick it up again at the back end of paragraph 206 on page 777, if you're still there, you'll see that the Act was preceded by a Law Commission report. And there was also consideration by the House of Lords Committee considering the bill of which Lord Wilberforce was no doubt a distinguished member, and he encapsulated what substantially more appropriate might mean, expressed a view that it would be a very rare case, was Lord Wilberforce's summary, in which the general rule would be displaced. Prima facie, there has to be a strong case, said Lord Wilberforce.
I think that this is said to be a strong case.
My Lord,
we'll be coming back to that, no doubt.
It is. Both parties will pray and aid the factors that they do, and then both parties will say it's a strong case in their favour. But that's the test. The test is it isn't just an ordinary balance that you just start from zero. It's a test which is tilted.
But on any basis, you would accept that on the assumptions we're asked to proceed, this is a rare case.
This is a rare case, but when I get to the factors, you won't be surprised to hear me say that we will be emphasising the relatively thin degree of connection to the United Kingdom and the primacy of the actions of the United States in all of this, and the fact that all the injuries and all the treatment and all the rest of it occur in foreign countries and not in the United Kingdom. The only connection to the United Kingdom is that someone pushed send.
So James, in terms of, I'm sorry I interrupted you.
Yes, no, of course.
In terms of the approach to Section 12 as opposed to its application to
yes.
particular circumstances, do you say that paragraph 25 of the judgment of the Court of Appeal in this case is an erroneous approach in any way? It's page 107, I think.
Yes.
Yes, my Lord. My Lord, we do have difficulties with paragraph 25 for reasons which I'm going to come to directly. They are principally going to be the narrowness of the focus on what tort means, and the idea that you can bring in as part of the test and or as part of the factors some notional imputation of reasonable expectations to the parties, both of which themes appear in paragraph 12. They also appear elsewhere in the judgment, notably and particularly in relation to the narrowness of the focus in paragraph 37.
Yeah, I mean, paragraph 25, the court says this requires the court to focus on the conduct of the defendant which is alleged to be wrongful, i.e. the tort. Whereas you say the tort's much wider than that.
I do. It's not very complicated, the case on either side, but that's the fundamental issue, and you see that picked up at paragraph 37. But I'm going to come to that. I'm going to come to that directly as my next point, if I may, when I come to make my submissions. I just wanted to give you one other reference, because I'll refer to it on a couple of occasions anyway. But there was, as you see from paragraph 206 of VTB in the Supreme Court, a Law Commission report that ultimately led to the structure and formulation of the 1995 Act, sections 11 and 12, in the form that you see them. You have that in the bundles. It starts at page 1698. I'm not going to invite you to turn it up now, but I just invite you to note, if you want to see the bits of it that particularly then fed into and led to sections 11 and 12 and how they operated. See particularly paragraphs 2.6 to 2.9 on page 1708 in the Law Commission report. But that, as is noted, was in 206 of VTB was an important pre-legislative published document that is of at least some interest in terms of the approach to be taken on the formulation of this. And the problem, essentially, without oversimplifying it, was that there was an assumption that English law would always apply as the lex fori, effectively, in relation to tortious claims. That was considered to be, to put it politely, parochial as an approach, and not consistent with the approach that lots of other countries took, which was a more subtle analysis.
This was under the old double actionability.
Under the old law, double actionability, yes. Boys and Chaplin, all the things my lord tried to teach me when he was trying to teach me. Evidently unsuccessfully, as it will no doubt turn out, but we all remember Boys and Chaplin and double actionability. But it was exactly that problem. It was considered to be parochial and to be, on another view of it, too complicated. So what they were trying to do was to simplify, create a general rule which would ordinarily do it, and then say you don't just reinvent the wheel when you get to section 12, let's tilt the test. That's essentially what they were doing, and they were doing that. I say they, I mean Parliament were doing that. Consistently with the recommendations and the analysis of the Law Commission that preceded it, and it appears of Lord Wilberforce in the Lords Committee, which considered the terms of the Act when they were drafted.
The paragraph 25 of the Court of Appeal's judgment, one of the points raised is that in considering this question, the party's reasonable expectation as to the law which will apply is likely to be an important factor.
Yeah.
My understanding of your written case is that you say that you don't join issue with it being a factor, but you say that its significance has been overstated. And so paragraphs 51 and 52 of your case.
Yes, my lord. I mean, our concern is, I don't want to dance on the head of a pin, our concern is that it appears to have featured very prominently in the analysis of the Court of Appeal, and that is problematic.
But it is a proper factor to be taken into account.
I'm not going to take my stand on it being wholly irrelevant.
Would absurdity also be a factor at that stage as well?
My lord, I think it could be. I'm not, again, objecting to that in principle.
And would it also be that persons can expect it to be judged by their own laws also be a factor at that stage?
My lord, that may be more difficult because that cuts more directly across the nature of the statutory scheme that Parliament has put in place.
Yes.
As I've described.
But it could be a factor, though.
It could be a factor.
Yeah.
But again, I'll make detailed submissions on those, if I may, when I get to them.
Yes, I would just want clarification as to what you're accepting about absurdity. I'm not quite sure I understand what that word means in this context.
Well, I think what Lord Stevens may be driving at is the point that he was putting to me earlier on, which is how do you do it if you can't decide?
Well,
Sorry,
How do you do it if you can't decide between the various states as to where the damage occurred and how that occurred? I think that may underlie my Lord's question. But
and also the points that have been made on behalf of the respondent as to all the constituent elements of these torts and the multiplication of issues that would then arise and apply.
my Lord, yes, although of course you will bear in mind that isn't that is an outcome. Various different states being feeding into different systems of applicable law at different stages of a sequence of events is something which is obviously contemplated by the Act, and there is no, as I understand it, there is no suggestion that there is any difficulty with identifying what the law of those states is. Those claims have been pleaded in the alternative and in detail in the amended points of claim, so there's no difficulty with identifying what the law may be in those states, and there's no public policy issue before you under Section 14 at this stage. So I'm not sure how far absurdity would go, but I get ahead of myself.
But it wouldn't be the case, would it, that we could take into account case management issues?
No, well, that would be in essence, once you stray away, my submission is going to be, once you stray away from the boundaries of the ingredients of the tort and the significance of the factors that play in, there may be some flex in Section 12, but the clear message from VTB Capital and the disagreement between the Court of Appeal and the Supreme Court as to application and outcome, it was very much focused on that. I think the concern that Lord Clark in particular had was that the Court of Appeal's analysis had drifted away from PILA and had moved into forum non-convenience considerations.
Sorry, PILA, you mean the Act?
Yeah, by the private international
Yes, okay.
the Act, the legislation,
Yes.
sorry, had drifted away from the Sections 11 and 12 analysis and had strayed into the territory of forum non-convenience, trying to predict what issues might be live and so on, and all factors that may feed into forum. That's a different set of analyses. They were concerned that the analysis should be kept tight on the ingredients of the tort, because that was the essence of the statutory scheme.
And you're going to come back to reasonable expectation, because that seems to me quite a problematic idea in a case like this.
I am. I wanted to start, if I may, with the first and might be thought main submission, which is headed necessity of considering all elements of the tort. And the key concern with the Court of Appeal reasoning that we respectfully have, and the key difference in approach between Mr. Justice Lane and the Court of Appeal, related to the narrowness of the focus and analysis of the Court of Appeal and how they identified what tort meant and implied. They focused, I hope it's fair to say, centrally and perhaps exclusively on the conduct of the defendants and their state of mind, rather than on all of the elements of the torts. See, by way of contrast, to illustrate that point, the judgment of Mr. Justice Lane at paragraph 60 and 69 as at least exemplars of his approach, a rather broader approach, and see also, we've looked at paragraph 25 in the Court of Appeal's judgment, the key one for present purposes, to which 25 is a precursor, is at 37. On page 143, 37 under their analysis. It's the first point they make under their analysis. They criticise Mr. Justice Lane for not focusing on the wrongful conduct allegedly committed by the services. And we make perhaps three broad points in relation to this first submission. First, we submit that in principle it is contrary to the statutory scheme in sections 11 and 12 to narrow the focus in that way. Section 11 establishes the general rule, as we saw, in relation to the country in which, quote, the events constituting the tort occur, The focus is therefore on the natural reading of that, on all of the elements making up or constituting the tort, not just some of them. Consistently with that, section 11.2 refers, as we saw, in dealing with things occurring in different countries, to elements of those events. The word events is tracked from one. Elements of those events occurring in different countries, and refers to the general rule in personal injury torts, to the injury, setting the general rule as being the law of the country, quote, where the individual was when he sustained the injury, as the general rule. Again, all of the ingredients or elements constituting the tort, not just the action of the defendant, but also other features and the injury in particular.
And that's true of B as well, damage to property.
Yes, that's true of B too. And you'll recall that when the Supreme Court were analysing the cause of action of deceit in VTB, they placed particular reliance not merely on the fact that the misrepresentation, the active misrepresentation, had been made in England, but also that there had been reliance in England and loss had been suffered in England. Those were the three elements. So similarly, in considering disapplication, if we go back to the statutory scheme under section 12, it's between the comparison, as we saw, was between the significance of the factors which connect a tort with the country of the general rule and any factors connecting the tort with another country that is required. That's the comparison that is required. Again, it's the factors we submit relating to the tort as a whole, i.e. all of its events or elements, to take the statutory language, which must be compared, not just the actions of the tortfeasor. Put it another way, the tortfeasor's conduct under this scheme, this statutory scheme, is not coextensive with the tort as a whole in all of its elements or with all of its relevant events.
But just looking at that, the CIA were asking their own questions and wanting to obtain information for their own purposes, for the benefit of their own country. And this tort, in asking those questions and assumed, and we assume that they were committing torture in order to obtain answers, those are distinct torts. Why should they be taken into account?
Well, my lord, I'll come to it in 1 second, but the primary actor, I submit, in all of this, particularly when one traces it back to work out what is causing the injury which is alleged, the primary actor in all of this is the Americans. The fact that they were asking some of their own questions, no doubt, to serve or to suit their own purposes, it does not, as it were, take them out of the equation or render the focus on the conduct only of the United Kingdom authorities a key feature.
I don't perceive the Court of Appeal to have done so for my part, because the whole basis of the claim is the questions were asked in the knowledge that torture would be applied by the CIA. But that, in looking at that particular tort, well, why do you take into account the separate and distinct torts committed by the CIA?
Because those are those are critical elements of the tort which is alleged against us. The tort which is alleged against us involves a claim in effect for personal injury, and the personal injury flows from the mistreatment and the prolonged detention which we...
In answering the questions.
Well, my lord, the questions were fed in, of course.
Yes.
On the assumed facts.
Yes.
But that doesn't strip out, as it were, the need to establish all of the ingredients or all of the elements of the tort. And the key elements of the tort, I will be submitting, when we get to the factors, the key elements of the tort cannot strip out or ignore the primary actor in all of this.
Assume for one moment that on day one, the CIA are asking all their own questions and committing torture in order to obtain answers to them. Day two, they ask all the questions that have been sent by the security services. Okay. Why should one pay any attention to day one?
Because on day one, they were doing the detention. They had picked up this individual. They had rendered him on the assumed facts. They had mistreated him, and all of those features, particularly the prolonged detention and the mistreatment, are said to be the things that cause the personal injury.
But the thing that caused the personal injury relevant to this these proceedings are the questions that were asked.
I disagree, my lord. That simply does not follow.
Yeah. So
The thing that causes the personal injury is the mistreatment, physical or otherwise, which might cause physical injury, and or the trauma, if that's the way it's alleged, which I think it is, of this individual having been picked up, held incommunicado, rendered, held in black sites for a prolonged period of time. That's what causes the personal injury. What causes the personal injury is not said to be, there we are, there are the questions that have been asked. They're questions. That is not the case that is being made against us. The case that's being made against us is there was conspiracy/common design and all of that. But the thing that causes the personal injury are the actions of the primary actor.
yes.
And the idea
If we stop the clock at the point at which the questions are sent, there's clearly no tort committed. The tort is committed when the CIA act on, or the American authorities act on those questions, plus personal injury. So in a sense you have two elements of conduct. One conduct is the defendant. Another necessary element is the conduct of a third party. And we've got damage.
Yes.
The necessary conduct of the third party and the damage are going on outside England and Wales.
Exactly so. Exactly so. And more, I submit, because it isn't just the asking of the questions. I mean, suppose he was held perfectly lawfully and questions were put over. I know that strips out the mental element, but it shows you where the significance of these elements lies. It's not just the asking of the questions that is said to be key here. What's said to be key here is that this individual was injured as a result of mistreatment. Mistreatment is not the asking of the questions, it's the torturing and all the holding unlawfully and all the whatever else.
Asking the questions during the course of torture, that's the mistreatment, that's the injury.
But during the course of torture.
But certainly for my part, I have difficulty in splitting these elements out in too precise or individual a way, because the allegation, as I understand it, which you accept for this purpose, you have to accept for this purpose, is a good one, is that there was here a conspiracy, and this particular party with which we're concerned is located in this jurisdiction and was carrying out acts from this jurisdiction in furtherance of that conspiracy, pursuant to which this individual was, on this assumption, tortured at a series of black sites, which even he was not aware of at the time.
Yes, but all of that conduct, and my lord, to some extent, I agree that it's very difficult to disentangle all of this too finely. My central submission is going to be, when we get to this, my central submission is going to be that when you look at this realistically, trying to find the factors, you start with the general rule, which is 11.2a. Where does the injury occur? Well, the injury plainly does not occur in the United Kingdom, it occurs elsewhere. Almost all of these torts, apart from trespass and false imprisonment, are actionable on proof of damage only. So that's the critical thing that Parliament has said you must focus on. You only take that out if you've got a clear preponderance of factors the other way. And when you stand back and look at the conduct, all of the critical conduct here is happening as a result of the actions of the Americans. If one looks at it purely from a causative perspective, it's not just the asking of the questions that is the problem, it's the fact that this individual suffers damage. What does he suffer damage from? It isn't the asking of the questions, it's the mistreatment. And we're not alleged to have mistreated him in any shape or form, whether in relation to detention or anything else. We're simply alleged to have asked the questions in circumstances in which it said we knew that he was being held in these black sites.
Well, as I understand it, what is said against you is that you are complicit in the activity.
Yes, that is undoubtedly said against me.
All of the activity, not simply by asking questions. You're complicit because you're asking questions from this jurisdiction.
Yes.
Which results in his...
My lord, yes.
Yeah.
But again...
But of course I understand your submission, which is that the person who was actually locking the door and so forth and everything else
and doing the torture
of a dreadful nature that happened thereafter was physically done
yes.
by other counterparties outside the jurisdiction.
My Lord, yes. I want to make it absolutely clear. No one on this side either is denying or could deny on the assumed facts that some part of this occurs in the United Kingdom. These are UK public authorities that are said to have sent the questions with the state of mind that we've discussed. And all of that connects it to the United Kingdom. But the exercise that we're engaged in here starts, as I say, from the premise that Parliament has said the general rule and the key rule that's got to be displaced is injury. Where does that occur? There's no dispute about that. So the question then is, how then do you strike the balance where these things are occurring in different countries? Because there are undoubtedly elements of all of this that are occurring, some here, as I've described, but some there. And the judgment for the court is where ultimately, I'm not going to use centre of gravity because that would get me in trouble on the analysis of VTB. You know what I mean? Centre of gravity in relation to the elements of the tort.
It seems to me one does need to be careful in talking about, for instance, conspiracy, because the pleaded case, going back to paragraph 26 of the points of claim again, is that from May 2002, the defendants were aware that the claimant was being arbitrarily detained. So it's not a pleaded case that there was a conspiracy to detain him, render him, and so on. As it seemed to me, the pleaded case was that the defendants become complicit in activities, conduct which is ongoing, and they become complicit, in a sense, by taking advantage of what's happening, so it is alleged, to ask their questions and try and get answers to their questions.
Well, I think that's a fair description, and just to give you another couple of paragraphs from the amended points of claim, where the conspiracy tort is itself directly pleaded, that's 49 to 51 of the AOPC. Can I come to that? I'm going to come to the constituent elements of the tort in 1 second. You've got the first submission, inconsistent with the statutory scheme, to do a thing that says, let's just look at the conduct. You've got to look at everything. You've got to look at all the elements. Bang, bang, bang. Unless you do that, that's inconsistent with the statutory scheme. That's the first submission. Second submission is that the distinction between the focus on the conduct and the focus on all the elements of the tort matters. It matters because if you focus tightly simply on the actions of the defendants, that skews the statutory analysis by leaving other, what may be key ingredients, key events, key elements, out of account. See, by way of illustration of that, VTB in the Supreme Court and the various ways in which the various elements of the tort of deceit that they took into account, including reliance and loss, where loss was suffered. And we submit that the Court of Appeal's analysis, effectively saying the judge was not entitled to take the breadth of view that he did, looking at all of the ingredients or elements, was an error of principle, because he didn't focus centrally or exclusively on the mere actions of the defendants. We submit that that in itself was an error, because, and the reason it matters is because those were central elements of the torts that are alleged. The actions of the CIA rendering C to different locations, the actions of the CIA in detaining the claimant, the mistreatment actually inflicted, the damage actually suffered. And in a little more detail, the pleaded claims require the claimant to establish not just that the defendant sent the questions, that's the defendant's actions with a particular state of mind, but also, and this is integral to the torts, that he was subject to mistreatment, torture, and arbitrary detention in the 6 countries, and that he suffered personal injury, the personal injury that he claims there. Those are essential elements of the tort. So they not merely reflect what Parliament has decided is the key general rule and factor that bases the Section 11(2)A analysis in personal injury claims, i.e. injury in its location, but they are also, that would also put the focus on the actions of the primary actor in relation to these allegations, the actor who is alleged to have detained, mistreated, and created the damage suffered. All of those are integral to and or at the heart of these torts. Now, the actions of the defendants are necessary too plainly, unless the questions are sent, there's no involvement of the defendants at all.
But I mean, the relevant sort of conduct element, so far as the defendants are concerned, is not just an action; it's with a certain state of mind.
It is.
And again, it's pleaded that the state of mind is looking to what will happen elsewhere, not in the United Kingdom. So, I mean, I suppose it's a point more for you than against. It's again, even looking at their conduct element, it's in contemplation of things which are going to happen outside the United Kingdom.
Yes, and that's what you're doing at the Section 12 stage. You've already got the general rule, because everyone agrees the injury doesn't happen here, it happens abroad. The question then is it displaced, and how do you approach that? And my submission on the law, as you know, in relation to Section 12, is that you focus on all of the ingredients of the tort, everything that is necessary to establish the tort. You don't just focus on the state of mind, i.e. the fact that the state of mind and the actions of the defendant, which of course we accept, happen in the United Kingdom and provide something of a link here. That's why we're having the debate under Section 12.
And just so everyone knows, I was looking at paragraph 28 of the amended points of claim to make that point, which is where the specific
contemplation of where
it will happen.
That was the paragraph to which my Lord Kitchen drew attention. Yes, I'm grateful.
And of course, it's obvious that they were contemplating it not happening in the UK, because we don't
do that sort of thing here.
We don't do that sort of thing here. But, or we hope we don't, or we didn't, or at certain stages in our history we did, and which is, happened outside the UK was a prerequisite for these questions being asked in contemplation of torture occurring. But it wasn't a prerequisite that it happened in any of these 6 countries.
No, it wasn't.
Yeah. And also, you've described the CIA as the primary actor. You said it's integral and at the heart of these torts.
I have.
And why then aren't you suggesting that those are factors pointing towards the law of the United States of America?
Well, my Lord, because the game that we play, as a result of the pleading and the assumed facts in the pleading, addresses either English law or the pleaded claim against us is the law of the 6 countries.
But the argument you're making seems to be supporting the law of the United States of America.
Well, that is one possibility. The other possibilities are the laws of the 6 countries, and those are the alternative claims that are made against us. I can see a case, someone could try and make a case for the law of the United States. I'm not making any positive case of that kind. But
one party or other would have to
one party or other would have to raise it and make the positive case, and then you'd have to determine it. But at the moment, the choice is between England and the law of the 6 countries.
But in order to defeat the law of England, you're saying that the heart of this case is the law of the United States of America.
No, my Lord, I'm not saying that.
But by implication.
I'm not saying it even by implication. At the heart of this case is the choice between English law and the law of the 6 countries. Those are the 2 alternatives that are pleaded, and there is plenty in the structure of the legislation to point to the law of the 6 countries as a matter of analysis. It doesn't follow from my submissions that the only available sensible game in town is the law of the United States as the only alternative to English law. At that point, I was going to go to the note on the constituent elements of the English torts that you had received. I'm sorry it's taken a while to get there. And it's just designed to summarise basic ingredients of these torts and to give you, I hope helpfully, the references to where they're pleaded in the amended points of claim, some of the paragraphs you've looked at, the basic allegation, what are the elements of the tort, and again, quite a lot of the punchline of doing the analysis in this way, as you will have no doubt appreciated, is that when you get into the elements, it becomes pretty clear that all apart from, we've had this debate already, all apart from trespass and false imprisonment, where I had the debate with my Lord about whether you could even bring that within 11.2a, because personal injury is said to be the consequence of the trespass to the person and or false imprisonment, but all the other ones, under English law at least, have damage as a necessary component or element of the tort. And you will see the various ingredients under the elements section under each of these torts. And that's brought to the fore by the headings under each of the torts of application, indicating the things that the claimant will have to establish. So we're trying to identify, I hope consistently with the statutory scheme, what are the relevant events or elements for present purposes. And you'll appreciate I'm going to this at this stage in the context of my primary challenge to the Court of Appeal's reasoning, which said really just focus on, or focus primarily or probably exclusively on the conduct of the defendants here with their state of mind. I say that's too narrow a focus, and that is illustrated by the elements of the torts that we have set out in this note. You will see it's in two parts. One of them does the a relatively simplistic analysis of what the various ingredients of the torts are. That's the first bit under the heading on page 1 of the torts. But the second element of the note is the basis of liability. And that makes the point that effectively what is being said here, or what is being said in the pleading against us, is that this was a case, or this is a case in which there is either joint or accessory liability. And we've given you the relevant principles, which will be very well known to you from Sea Shepherd and Fish, the common design principles, in that case in the Supreme Court, and we've given you the references into the electronic bundles there on the 4th page.
I'm sorry to bring it back to paragraph 25 of the Court of Appeal's judgment. And your first ground of appeal relies upon, this requires the court to focus on the conduct of the defendant, which is alleged to be wrongful, i.e. the tort. If you go back to paragraph 1 of the judgment of Lord Justice Mayles, he sets out the essence of the claimant's claim, which involves the CIA mistreating the claimant at black sites in 6 different countries. So when he's referring to the wrongful conduct, he's referring to the wrongful conduct which involves the CIA.
Well, my Lord, of course he is to some degree, but I think it is fair to say, on the basis of this judgment, the principal disagreement, the principal basis on which the Court of Appeal saw fit to or considered that they were able to introduce their own assessment of the right answer was because they concluded the judge had made an error of law. And the error of law, if I can summarise it, the principal error of law they identified was that he had not focused tightly enough or exclusively on the conduct of the defendant, which is alleged to be wrongful. The defendant here being the United Kingdom authorities, to take that from the 3rd sentence of paragraph 25. And then they say, i.e. the tort. That's the principal source of disagreement between the Court of Appeal and Mr. Justice Lane.
But they define the conduct of the defendant as involving the CIA.
I think that's what's an issue.
Yeah.
That they seem in paragraph 25 in that sentence to narrow down the tort just to the conduct of the defendant, and then one sees the dispute with the judge appearing particularly from paragraph 37, where the judge has, well, on one reading of his judgment, he's adopted the all elements of the tort approach, and they say, no, that's wrong. He should have focused just on the conduct element. Yeah. Anyway, that's the area of debate, whether that's right or wrong.
That's the area of debate, and that's the issue. And we respectfully submit, if you tighten up the focus in that way, you create an analysis which is inconsistent with the statutory scheme and leaves out critical elements. And the reason for putting in the note is to emphasise that if you do look at all of the elements of the tort, they include damage, they include the actions of the third party, brackets, actions which themselves are said to cause the damage directly, namely the actions of the Americans. True it is, of course, they refer to the Americans because that's the essence of it. But having done so, when they then come to do the analysis under the Act, they tighten up the telescope. They tighten up the focus so that it's only on what the defendant does. They don't take into account reality, and of course, that's the critical comparison. It's happening in different places. There are some connections to the United Kingdom, as I've accepted. There are many more we respectfully submit to jurisdictions outside the United Kingdom, and they also include the actions of at least two parties. And what the court's function, what the court is told to do under the legislation, is to make a judgment about the significance of those factors linking them to one or the other. So you've got to do an evaluative exercise of some kind. And we respectfully submit that for that purpose, to leave out of account, or effectively to leave out of account, the actions of the third party here in America and all the damage and all the location of it, is, we respectfully submit, not the right approach, and not the approach that Parliament has prescribed. It's for that reason that the nature of the liability that is alleged against the defendant is important, because if it's either joint liability as it is, or accessory liability in respect of the alleged mistreatment by the United Kingdom, in either case, it's either joint or the United Kingdom is the primary actor for which we are accessorily liable, as it were. But it's all the more artificial and unjustified then to focus simply on the actions, the mere actions of the defendants.
Could I just ask you about that?
Yes.
What you're now focusing on under the basis of liability on page 3 of your note, the allegation is therefore one of joint or accessory liability. I mean, looking at the pleadings, I would accept that that's how it's been pleaded in respect of trespass to the person, including false imprisonment. And I suppose it would be difficult to think of a conspiracy tort that wouldn't be classed as joint or accessory liability. But in terms of misfeasance in public office and negligence, I would have some trouble accepting that they are pleaded in this case as cases of joint or accessory liability. It seems to me a separate point that on the facts of this case, the misfeasance involves the conduct of a third party. That, I think, is not the same as what we mean by joint or accessory liability.
No, well, I accept that clarification, but in relation to both of the torts that you've mentioned as falling potentially outside that analysis, a key point perhaps is not the one of joint or accessory liability, but that damage is an essential ingredient of the tort. So you have to then ask the question, how does the damage occur? If the damage here is personal injury, that flows from the actions of the third party. So the question we're really debating is it a sensible or appropriate approach in principle under section 12 to leave out of account what are key elements of the tort if they involve looking at damage, if they involve looking at the actions of third parties as an integral part of damage, if they involve the third party being involved as the primary actor in the way that I've indicated.
No doubt we'll come back to this, but as I understand it, the case that's put against you is that these activities involving the third party, or the co-conspirator, however one likes to term that party for this purpose, happened in a series of different countries in black holes at the instigation of this co-conspirator or third party, and the victim did not in any way submit to those jurisdictions and was moved from country to country, black hole to black hole, where he could be tortured, so it was supposed, most effectively. And that continuing activity would remain undetected and uninterrupted by any authorities in those jurisdictions. And that, as I understand it, is an important part of the conduct or the overall picture which drives one back, or is said to drive one back, to the law of this jurisdiction being the appropriate law to apply in considering the liability of the parties for whom you appear.
My Lord, yes, I'm going to come, if I may, when I have a section dealing with the factors. May I come to those points down? I'm very aware of the fact that that is the way it is put. These are black holes, so there's no real significance attached to the fact that it's the 6 countries in which it occurred, because the only thing was that they were A, not England, Lord Stephen's point, and B, they were somewhere else.
Had this particular victim been run over
Quite.
In one other country, that would be a very different case. But we're concerned with circumstances here which, on the pleadings, are about as far removed from that situation as one might imagine.
My lord, they are, and I fully accept that, of course. So the question is, what then do you do where you've got this concatenation of circumstances and actors and locations? And you have to make a choice. So the question is, how do you go about doing it? And do you put, in essence, the very simple question is, do you put do you put in the scale so as to enable it to tip against the shifted balance? Do you say, well, there's sufficient connection to the UK to achieve that object, even though it breaches the primary rule, the general rule? Or do you focus on a broader range of circumstances linked to the elements or ingredients of the tort? And if you do, what significance do you attach to those? And that's the very debate. And I'm sure my learned friend will say, as my lord has just put to me. And I'm going to come to that specifically when I get there.
Just before we leave the basis of liability point,
yes,
and just picking up from what Lord Burrows was saying, I think in answer to his question about misfeasance and negligence, focused on where the damage occurred. But it did seem to me that there's another element as well, that for both of those, you need contemplation of where harm is going to, of harm happening, and hence in this case of where the harm is going to take place. Because it's only if you have that contemplation, for instance, that you could owe a duty in negligence. And for misfeasance, it's only if you're contemplating that something will happen and taking steps to enable that to happen, that liability will arise. So it just seemed to me that potentially it went a little bit more than just, well, the damage occurred here.
I accept that, and it's, to some extent it's a similar point to the point you were putting to me earlier on about the fact is that they were contemplating things happening that wasn't going to be happening in the United Kingdom. But yes, I accept that. I've referred to the nature of the liability, and one can illustrate essentially the same point in a number of different ways, but one of them is to take a realistic view of causation. What causes the alleged injury on the pleading case? It is, on any view, not purely the act of putting the questions in. It is, in fact, the rendition, the detention, the actual mistreatment that leads to physical injury, but the trauma that is suffered from each of those things. And the United Kingdom authorities played no role, in a direct sense at least, in any of those.
It's the latter observation or submission that I have some difficulty with, but
because of the mental element.
Yes, and the way the case is pleaded, and on the basis of which we must proceed for the purpose of this appeal.
Yes.
But there it is. Subject to that qualification, I understand your submission.
Yeah. And the point I'm really on here is it appropriate simply to focus on the defendant's actions, as the Court of Appeal has done, or do you look more broadly? And that will require you to make those sorts of judgments about the intricacies of the various elements, all of them, the basis of liability, the reality of causation, and all of that. But that opens a door into the analysis of the first instance judge, which was broader, took into account all of these features, fully acknowledged the points that my Lord Kitchener has put to me on a number of occasions about the state of knowledge of the defendants, which is alleged, and so on, took into account all of that, but also took into account this broader range of circumstances. And the question really is whether the Court of Appeal was entitled to say, no, that was an error of law. And the error of law that they identified is the one in paragraphs 25 and particularly 37. And if that goes, then you are left with the judge's analysis, and you will bear in mind in relation to that the point that I drew specific attention to when you were looking at the judgment of Lord Clark in VTB, which is this is paradigmatically a matter of assessment for the judge standing back and weighing the preponderance of the significance of those factors under section 12. But if you say the focus can be broader in principle and should be broader in principle, which is my submission, then the judge rules the roost, and there was no error of law which would have entitled the Court of Appeal to form its own assessment. And my third submission is that the narrow Court of Appeal focus, if I can describe it in that way, on the actions of the defendants and their state of mind is not justified by stating, as they do in paragraph 37, that this is not a claim against the CIA, or that what is required by section 12 is a focus, as they put it, on the tort committed by the defendants. This is indeed not a claim against the CIA. It's almost inevitable that the United States, if sued, would assert immunity, and that's what has been done, it appears, in related US proceedings. But the applicable law is determined in accordance with the statutory scheme for doing so in sections 11 and 12. It would be surprising indeed if it depended on the forensic choices by claimants, or on whether or not, under international law, there might or would be likely to be a barrier to suing another party. In any event, the fact that this isn't a claim against the CIA does not undermine the need to focus on all of the elements of the tort. And they include as key or central elements allegations about US action and the consequences of that alleged action. So that's not a claim against the CIA, that part of paragraph 37. The second part of paragraph 37 was section 12 requires focus on the tort committed by the defendants. And, as it were, as stated, and as long as you understand correctly what tort means for that purpose, we agree. The area of disagreement is that they took tort to mean something much narrower than we respectfully submit they should have taken it to mean. The correct focus under the statutory scheme is on all of the elements, and then you make the judgment from that point. And the analysis of the CIA actions are, on any view, plainly relevant to an analysis of the degree of connection between the tort and the jurisdictions being considered. So that's our first and primary submission. Too narrow a focus. If that goes, it's a broader perspective that is needed, and if that's so, there's no reason to disagree with the learned judge.
Again, I just interpose by asking one further question.
Yeah.
As I understand the Court of Appeal analysis, it is said, the Court of Appeal reasoned that the judge made two errors. One is the one which you've identified, and the second is that the judge was wrong to discount the reasons advanced by the claimant in saying that the factors connecting the tort with those various 6 countries were of reduced significance. So if you were right in relation to your first point, would it necessarily follow that the Court of Appeal had no basis to interfere with the judge's analysis?
My Lord, I would have to address the second one, but I do respectfully submit that on their analysis, the key part of it was this narrow focus on the actions of the defendants. Of course, there are 2 reasons that are given and 2 bases. My Lord is right. I don't quibble with that as an analysis of their judgment. But I do submit that if that is right, then the court would have to sort out the mess that then follows, as it were. But this court would have to do that. But if you decide that the focus should be broader, you would then have to decide that there was sufficient in the second point to warrant the court making its own judgment. And I'm going to make submissions about that second aspect in a moment. If
I mean, analytically, I wouldn't have thought there's very much doubt. If the judge has gone wrong, then his assessment doesn't stand.
Yeah.
But if the Court of Appeal has gone wrong as well, then its assessment doesn't stand, and then it would come to us to make our assessment.
That's what
but you have to ask both those prior questions before it comes to us to exercise the discretion.
Yeah.
Just before leaving your first point, I just want to tease out this continuum. The judge referred to it as a continuum. But at present, I don't understand you to be accepting that in the sense that the defendants obviously aren't liable for all the personal injuries sustained over the whole period of time that the person was detained in these various black holes.
I think that appears to be the claim. I'm not sure there's any distinction being drawn by the claimants. That says only for that part of it or only whatever. They make allegations about the state on the data.
Are you suggesting that we should approach it on the basis of a continuum where the defendants are potentially liable for all the personal injuries sustained throughout the whole period.
That is, as I understand it, the case against me.
And I thought you had an argument about causation, and that was that the claimant would have to establish what personal injuries were attributable to these particular torts and the questions that were asked.
My lord, we do, but at the moment we're proceeding on the basis that the claim against me is assumed to be true.
And whereabouts do I turn up in the amended statement of claim that basis? That is a continuum and you're liable for everything.
I'm not sure. Could someone find me?
Yes, if you could, I would be grateful. I'd like to see that.
Helpful.
Yes. Yeah.
Well, I'm going to come back, if I may, to the significance of the factors. I just wanted to interpose a second area just before coming to the significance of the various factors, try and pull those together for the purpose of section 12. And I just wanted to touch very briefly on an aspect of the Court of Appeal's judgment, which perhaps isn't absolutely central, but I ought to deal with, and that is the aspect that is to do with NCND, neither confirm nor deny, and or predicting the outcome of live issues that would fall to be determined at trial. And I do that because they also appear at least to have relied, in support of their narrow approach, I focus only on the conduct and the state of knowledge of the defendants, on a prediction of the issues that would be likely to arise at trial, and their reasoning in essence appeared to be that the only live issues would not be in relation to the actions of the US, but would simply be in relation to the state of mind of the defendants. That was the part of it. And so it was implied or said that was where the focus should be for the purpose of the applicable law analysis. I hope that's a fair summary of what they were doing. And at the heart of that approach was a slightly beady eye view of the defendants asserting NCND in open and in their open defences. I wanted to pick up those two aspects. First, you will see in relation to NCND, or you will have noted the paragraphs in the Court of Appeal judgment that deal with that, which are essentially paragraphs 12 to 14, and the core of it is perhaps at paragraph 13 of the Court of Appeal judgment. And there they concluded that the availability of material in the public domain and the defendant's NCND stance meant that it was unlikely that there would be any real dispute about the fact that the claimant's rendition occurred to the 6 countries, so they consider the critical issue is likely to be the service's awareness of the treatment to which the claimant was or would be subject. So they're effectively taking a position that says, well, we can narrow down applicable law analysis because of what we regard as being likely to be an issue. And the submission that I make is simply a submission that that sort of conclusion and its basis were not appropriate to be made in a case such as this. As the court will be aware, the judge at first instance had made a Section 6 Justice and Security Act 2013 declaration. All of you know what that means. That means that the court has given permission for there to be a closed material procedure under the statutory processes that that Act sets up to enable parts of the claim which raise national security concerns to happen enclosed, with the claimant's interest in effect being represented by special advocates.
I'm sorry, I didn't note the statute.
It's Justice and Security Act 2013, Section 6.
Thank you.
I wonder, Sir James, if there's a prior point here, and that is, to what extent is it appropriate for us to be looking at the question of how issues would be handled at trial, which would seem to be a matter going to forum,
like VTB.
Whereas here we're actually concerned with the question of the applicable law.
My lord, that is the second half of the submission.
Right, sorry.
It is the VTB problem. that was the fundamental criticism that Lord Clark made of the Court of Appeal's approach. If you try and work out what the true issues are going to be, then it becomes intensely problematic. That's beyond the focus of the statutory scheme. I do make that submission. The one I'm on at the moment is about the appropriateness of saying you've made an NCND, you've taken an NCND stance, and as a result of that, it doesn't seem likely that anyone's going to be fighting about any of these issues. Now, I should, in fairness, I should make clear that this has quite a complicated little procedural history attached to it. The judge made a Section 6 JSA declaration. That opens the door for closed material procedures. What that means is that the government does not have to plead by way of defence things which would cause damage to national security. And as you will be aware, there's lots of debate in these sorts of cases driven by the special advocates about what should go from closed into open. But he makes a Section 6 declaration. The concomitant of that is that the government is able to say NCND in relation to those allegations which it can't respond to properly for fear of breaching and causing damage to national security. What happened here was that the Section 6 declaration was made when the applicable law issue, as I understand it, having not appeared at either level below, but as I understand it, what happened when the applicable law issue came before Mr. Justice Lane, the defendant's skeleton invited him to read the closed defence that had already been put in by that point. You don't have that open skeleton in the bundle because it's in Appendix Part 2 and you don't need it for this purpose. I'm not going to trouble you with more papers, but he was invited to read the closed defence for that purpose. The difficulty that then arose was that the second lockdown occurred. You'll note the date of the judgment on which Mr. Justice Lane delivered his judgment, which is, I think, February 2021. So second lockdown hearing happens. The result of which was, as I understand it, that he said, well, I haven't had and haven't been able to have delivery and receive delivery and read the closed defence, and so the proceeding before him progressed on the basis of an agreement, as I understand it, by all sides, that it should be entirely open. And no doubt that was in part driven by the fact that the way in which everyone was approaching this was to assume the facts and the points of claim to be true. But he hadn't read and didn't read the closed defence at that point. There was then a Court of Appeal hearing. That progressed on exactly the same basis, and you'll have seen the reference in paragraph 12 of the Court of Appeal's judgment, we have not seen any closed material. That's correct. Everyone proceeded on the basis that this was purely open because that was the basis on which the judge had approached it. There was no interest expressed by the Court of Appeal in seeing closed material or identifying anything of that kind. The only reason I go through that procedural history is because it makes it rather doubly inappropriate, as it were, for the Court of Appeal to be holding NCND in effect against the defendants for the purpose of trying to narrow the issues, for the purpose of supporting the argument that says we can look at the conduct of the defendants narrowly and keep the focus tight in that way because there's unlikely to be an issue. But we respectfully submit that that isn't and wasn't an appropriate course to take to the extent they did that, and they appear to have done.
So when you say they appear to have done, where do we pick that?
Well, you get that from paragraphs 12 to 14.
So are you saying that paragraphs 12 to 14 somehow feed into that sentence in paragraph 25 about focusing on the conduct?
And 37, they appear to be, they don't do it expressly, but they do make the points about the basis on which they're proceeding, no doubt advisedly, in paragraphs 12, 13 and 14. And that's got the two bits that I've identified. The first of them says, well, we pleaded NCND. They're not going to say whether that was proper, but there's unlikely to be any dispute about anything apart from the defendant's state of mind. That appears to have fed through into their reasoning. And I respectfully submit that to the extent that it did so, that wasn't an appropriate approach.
How does it connect in? I mean, your first ground of appeal is the focus on the conduct of the defendant.
Yes. And the reason I'm going to these paragraphs, it doesn't feed in directly. They don't say when they get to the 25, 37, particularly 37 and onwards, they don't say, well, we're now doing it for that purpose. But unless you assume that the findings that they make and the comments that they make in 12, 13 and 14 are irrelevant, and they don't appear to be, they are, as it were, the lead-in, and they are all grist to the mill, it appears, that says we can focus narrowly. I mean, you either ignore them entirely, in which case fine, but the Court of Appeal don't appear to have done. But in any event,
they say in paragraph 13 that the availability of material in the public domain, this is the material that you object to. That's the ECHR judgments and the Senate rulings. Suggests there is unlikely to be any serious dispute about the fact that the claimant's rendition to the various countries listed above his detention of CIA black sites. And it also ties in with paragraph 12 of the Respondent's case, that in fact there's a report from the European Parliament which actually can track rendition flights. Mr. Zubaydah's rendition flight stopped in London to refuel. I mean, the Court of Appeal were suggesting that the material in the public domain would seem to suggest that there wasn't much dispute about that.
Well, my Lord, my submission, you understand, is a more limited one. My submission at the moment is about NCND, but if you take it more broadly than this, the position, as we're all agreed, is that the court proceeds on the basis of the assumption that pleading against it is true.
Yes.
This is not an exercise in which the court is determining facts.
Sorry, can I just check? Was that the agreed basis in the Court of Appeal? I've just been trying to see whether they specifically say we will proceed on the basis of an assumption that the pleading is true.
I think that was the...
Yeah, it may well have been.
We'll see whether it's recorded anywhere, but my understanding is that that was the basis on which both parties were proceeding.
Okay. Well, I mean, I can see against that background, paragraphs 12 to 14 are a bit odd. Why do they even need to talk about?
Why are they going there? Why are they making findings of, in effect, findings of fact, as they do at the latter half of paragraph 14? My Lord Stevens says that these are some of the things I object to. The only thing I object to, in a strict sense, is the ISC report because of Article 9. The other reports I respectfully submit at this stage are irrelevant because the approach is assume the facts to be true and not making findings of fact, whereas what they seem to have done is to approach this on the basis that they make do a mixture of reliance on NCND and or inferences from public documents to say, well, actually, the issues are likely to be narrow. That's problematic in NCND terms because there's no basis for saying that. They don't know what's going on enclosed or what would go on enclosed. But it's also problematic more broadly for the reason my Lord Lloyd Jones identified, which is that they're not here doing forum things. They're here doing applicable law things. And that's precisely the vice, or one of the vices, that was identified by the Supreme Court in VTB. But I do submit that there is no basis and no support should be provided or could have been provided to their narrow approach in principle if this is what they did, and there must be some significance to 12 to 14. That is not an appropriate exercise, and it certainly does not lead to or could not provide support for narrowing the issues to the focus they ultimately put on it.
Just in case I misunderstood you, did you say that in the closed material procedure, that is in closed proceedings, the defendant doesn't have to plead by way of defence?
No, I didn't say that.
You don't? No, but I picked it up wrong.
You do have to plead, and you do.
It just struck me as very, very bizarre.
If I did, I misspoke. No. What you do...
Of course you do. That's the
whole point of it.
Yeah.
No, you definitely do, but you do it enclosed, and NCND is the concomitant of that. So it means you don't have to prejudice national security. That was the whole reason for setting up the process.
And you can make applications for various things enclosed to be brought into the open.
That's what the special advocates regularly do, unless they, you always have a debate around.
And there's a special advocate present in court today.
No, but they were present, as I understand it, although not named.
Yeah.
They were present on the video call or the video hearing that preceded Mr. Justice Lane's judgment.
Right.
They were not present, as I understand it, in the Court of Appeal.
Yeah.
No doubt because everyone said we're doing this on the basis of pure open, because that's the way in which Mr. Justice Lane, as it were, accidentally proceeded. Anyway, I don't want to take too long on this, but you have the points about the difficulty of paragraphs 12 to 14. I hope the core point perhaps is that that's not an exercise which could have justified in any way the approach that was taken to narrowing the focus in the way that they did. So my submission up to this point is that Mr. Justice Lane correctly focuses on all of the ingredients, committed no error by not focusing narrowly on the actions only of the defendants. There's no basis for that narrow focus under the statutory scheme. Indeed, it's inconsistent with it. And there was no basis for doing so by seeking to rely upon, if that's what they did, the narrowness of predicted issues or NCND. And my next submission is that if that's right, then there was no proper basis for interfering with Mr. Justice Lane's judgment, paradigmatically for him, as the first instance judge, in his analysis of the significance of the factors connecting the torts to the 6 countries. Once the correct approach to analysing all of the elements of the tort is applied, it is clear, we submit, that the Section 12 comparison comes down heavily in favour of the applicable law being that of the 6 countries. I've emphasised that the starting point of the Section 12 analysis isn't a simple balance. I don't repeat that point. It's heavily weighted in favour of the general rule already. The core features in favour of the maintenance of the general rule are that the injury is and was alleged to have been sustained in the 6 countries, not in the United Kingdom, hence the general rule. All of the treatment leading to that injury, unlawful rendition, detention, torture, mistreatment, is said to have taken place in the 6 countries. I'm not going to go back on the contentiousness of this, but I'll make the statement anyway, or the submission anyway. The primary actor throughout on the claimant's case was the US authorities acting in those countries, not in the UK. The factors connecting the matter to the UK are, I respectfully submit, not sufficient to overtop the weighted balance. So there's no suggestion or claim of anything happening on UK territory at all. There's no suggestion that decisions as to the location of the claimant were taken by anyone other than the US authorities. There's no suggestion that any decisions as to the claimant's rendition, movement, or treatment were taken by anyone other than the US authorities. The claimant is not a British national, has never had a right to enter, and was never in the United Kingdom. And to the extent that the defendant's conduct, which obviously is to be taken as having occurred in the United Kingdom, of sending the questions with the state of mind alleged is concerned, that certainly does provide a connecting factor to the United Kingdom. But it is, I respectfully submit, needs to be borne in mind, as my Lord Sells has put to me on a couple of occasions, that had its focus in terms of their state of mind in relation to treatment outside of the United Kingdom anyway. So in truth, the only thing that really connects us to the United Kingdom is that the United Kingdom public authorities push send in relation to those questions, and that does not lead to the United Kingdom's law being substantially more appropriate per Section 12. The Court of Appeal, in relation to these factors, placed some reliance, if I can turn to this, on the idea of the reasonable expectations of the parties as a factor supporting the connection to the UK. So this is the reasonable expectations bit. And I submit that isn't a concept of any weight or real significance here. And it's not a factor of any real significance, I submit, for at least 4 reasons, if I may shortly. Firstly, there was no choice by the parties, whether express or implied, as to the applicable law to govern their relationship. The location of detention was dictated on the claimant's case by decisions of the US authorities. This isn't a situation in which that concept could sensibly have any traction, I submit. the reasonable expectation of the parties in a context like this, it might be thought, would be entirely speculative. If anything, if the claimant or anyone else was asked, it might be thought that either it would be the law of the countries in which the claimant was located, on the basis of territoriality, general rule and all of that, or perhaps the unpleaded claim that Lord Stevens put to me, that it might be the law of the country inflicting the harm, which is the US. But none of that leads to English law. So the exercise of predicting what the expectations would be, or notionally ascribing or imputing reasonableness to them, is an intensely problematic one in this circumstance.
In more normal circumstances, it might be said that there was an implied choice by a person voluntarily presenting himself in another jurisdiction. And there's a normal assumption that if you go to another country, then you're subject to the laws of that country.
Yeah.
We're a very long way from that.
We are. But I respectfully submit that's a point in my favour, I hope, at least for the purpose of this argument, because if you're saying that the reasonable expectation is that it would be English law, that I do submit is a very difficult exercise. And a difficult
it's the reasonable expectation of both parties, and it's objective, isn't it? It's objective.
It is objective because it's reasonable.
And and so, are you saying it was the reasonable expectation of your clients that it would be the law of these 6 countries?
Well, my lord, I don't need to say that. The question is,
well, if you're
that assumes a subjective judgment being made by individuals. We're dealing with situations in which, like the situation that my Lord Jones just put to me, where a person, as it were, implicitly subjects himself to the laws of the foreign state by driving on the highway in Australia or France. We're not in that situation here.
I think the Court of Appeal described it as fanciful, that the expectation would be, on behalf of the security services, that the laws of the 6 countries would apply on an objective basis. Reasonable expectation that they would apply. They didn't know which laws were. And,
well, my lord, I've no idea whether that's right or wrong as an exercise of predicting what someone might or might not have expected. My fundamental point is that this isn't a doctrine, this isn't a concept which in a case like this actually can help to identify what the correct applicable law is, because it does involve speculation on both sides and all sorts of objections. This isn't a situation in which reasonable expectation carries any weight. I submit in that situation what you do is you look at the analysis that Parliament has said you should undertake, and that involves focusing on the ingredients or the elements of the tort and working out what the significance of those ingredients or elements actually is, judged properly. To introduce this is to introduce a very, very difficult, controversial, uncertain, extraneous factor into that analysis. And I make the same point in relation to the second of the features that the Court of Appeal relied upon. In paragraph 42 of their judgment, justice is done to a person if his own law is applied. The short answer to that is that that's very hard to square with the special statutory regime created by sections 11 and 12 of the 1995 Act, which gives precedence to the general rule that the law of the place of harm is the one that is the applicable law, and it can only be displaced if it's substantially more appropriate to do so. That's a statutory regime, and it's not a regime which can or should be displaced by applying a rule or a strong presumption that the law of the defendant is the applicable law.
But is that how the case is put against you? Because as I understand it, it's rather that in circumstances such as those which we've debated a little bit earlier during the course of this hearing, there may be circumstances, and this case is one, where the choice of the most appropriate law to do justice between the parties drives a different conclusion. And where it isn't known where this individual was, he didn't submit himself to any particular jurisdiction, he's been subjected to torture over a long period of time, the UK has, on this assumption, participated in that torture, justice requires that a convenient forum is chosen, the law of a convenient forum is chosen, and it is appropriate in those circumstances that it should be the law of the jurisdiction where the defendant is based.
My lord, well, that would render the law of the place at which the defendant is based as somewhat adventitious. My submission is that the appropriate thing to do under the Act, the appropriate analysis to conduct under the Act, is to focus on the elements of the tort, to work out where all of the ingredients, events or elements take place. We know that they take place, so far as the allegations are concerned, in the 6 countries. So you have a straight choice between one set of laws and another. And the question is, where should it be located? The mere fact that the allegation is that the defendant's state of mind was such and that the person was being moved between one black site and another, and to some extent it's accidental that those 6 countries are there, is neither here nor there. We know that the conduct alleged occurred in those countries. We know that that was where injury was sustained, and that wasn't England. And in my submission, to then introduce a thing that says, well, because these allegations as made are all ghastly, it should be, as a matter of justice, as it were, the law that governs the United Kingdom authorities, I submit is not consistent with the approach in the statutory scheme. And if underpinning my lord's question is in part the idea that it's the court's function to provide, as it were, a convenient and more appropriate and helpful law for a claimant bringing this sort of claim in these circumstances, that doesn't have much traction, I respectfully submit, for at least 2 reasons. One of them is that if you've got factors of public policy that render a foreign law inapplicable for this purpose, the statutory scheme makes provision for that in section 14. That's the appropriate location for that sort of analysis. And the second answer to it is the purely practical one, which is that you are not confronted here with a claimant who says, we simply don't know, or they've got no law that renders this sort of awful conduct unlawful. They have pleaded their causes of action in the alternative under the laws of the 6 countries. And my submission is, therefore, there is no warrant in this case either to adopt a broad stand-back approach that tries, as it were, to assist the claimant in this way because the allegations are against the public authority and not serious, or that warrants, as it were, introducing some form of presumption or rule that says, as the Court of Appeal appears to have done, that it's a well-known axiom that justice is done to a person if his own law is applied. I mean, that would drive a coach and horses, I respectfully submit, through both the Section 11 and the Section 12 analysis. So my plea is that you follow and faithfully follow the terms and the logic of Sections 11 and 12.
I mean, the last sentence in paragraph 41 in the Court of Appeal's judgment on page 111, it's focusing on the conduct. Again, similar to we've seen in paragraph 25 and 37. And that's not really what we need to be focusing on. As for the services, they would reasonably have expected that the tort that they had committed would be subject to English law, is what should have been the analysis. But then, of course, that would be problematic.
Yeah.
So it's another example of where they've decoupled, it seems to me, the
conduct from the
tort and the conduct. And again, paragraph 42, last sentence, conduct.
Yeah.
It's all the time focusing, instead of focusing on the tort, it's focusing on the conduct.
But that in turn depends upon whether the conduct involves the conduct of the CIA in paragraph 1.
Well, my Lord,
my
respectful submission is that can't work as an argument. On any fair reading of the judgment, they disagree with the judge because his focus was broader. That's what they're doing in paragraph 34.
They disagree on the basis of a continuum, and as yet I haven't seen the pleading, and so no doubt I will do shortly.
I mean, speaking for myself, I think Lord Burroughs' point on the last sentence of paragraph 42 is correct, just as a matter of interpreting what the court was saying. Was they're talking about the services, that's the UK services, can't say it's unfair for their conduct to be judged by the standards of English law. But I think that is talking about the UK defendant's conduct.
Yeah. And I have two objections, if I may respectfully say so, to those sentences. One of them is the one that my Lord Sells has just identified, and the other one is that who knows? It's my speculative point. They might well have said, well, I'm a service member, and I've read with great care the relevant statutory scheme, and I know that the general rule is that it's the law of the place at which the injury was committed. Who knows? It's an entirely speculative and non-helpful extraneous thing to introduce into the analysis, I respectfully submit.
And in a case like this reference to reasonable expectations is just a complete fiction, isn't it?
It's a complete fiction because it has no grounding in the statutory scheme, but more significantly, perhaps, if you say, well, Section 12 opens up a big, broad vista, it doesn't actually help to answer the question, because unless you can say this is the bog standard case in which someone has gone to France and driven in France, you don't get any clear, implicit or reasonable choice of that kind. And so it's a non-factor. It's the introduction of an extraneous factor.
I mean, in a sense, if one's looking at the tort as opposed to other public law duties and so on which yes. might exist, it might be said to be completely adventitious, both from the point of view of the claimant and from the point of view of the defendants, because they don't know where he is. Neither of them know where he is.
Yeah. Well, true too. I'm not going to ask my Lord Stevens to, well, perhaps I'll ask and then leave it, that he reflect on paragraph 37 again. I've been back to that on a number of occasions in the Court of Appeal's judgment, and I do respectfully submit that that's where you get the clearest indication of the nature of the disagreement between Mr. Justice Lane and the Court of Appeal, and it does involve a much, much narrower focus on the conduct and state of mind of the defendants. You can't just drag in the Americans, because it was the dragging in of the Americans that they thought was problematic from Mr. Justice Lane's judgment. That's the second point, which is justice is to be done if his own law is applied. Same objection to reasonable expectation in a way. It just introduces a presumption or a rule or some sort of thing as a factor that says apply the defendant's own law. And that isn't what the statutory scheme requires. Then it is contended, and it's related to that point, that it's appropriate to hold British officials to account under the law of misfeasance, presumably because they're British officials. But as to that, three short points perhaps. The legislation applies equally to claims against the Crown. See section 15(1), page 425. There's no basis to carve out a special rule for the particular tort of misfeasance. Doing so in any event, second point, amounts to a public policy argument, and the place for that argument, if at all, is under section 14 sub 3 sub A sub Roman 1. Those arguments would fall to be analysed as against the claims made under foreign law. And thirdly, that would amount in effect to a parochial application of the laws of the forum, which was one of the very matters sought to be remedied by the introduction of the legislation, as the analysis of the Supreme Court in VTB that we went to earlier, relying on 103 to 104 of Lord Justice Brooke in Al Jeddah, plainly indicates. We also invite you to note, as perhaps the fourth point in relation to all of this aspect, that the claimant quotes from the Law Commission paper at paragraph 4.13, that's on page 1619 of the electronic bundle, but that, if you go back to it at some point or have it now, refers to the expectations of the parties after the tort has occurred, with the emphasis on after in the original text. That is to say, it makes clear that the expectations are not relevant to what predictions the parties may make about applicable law, but are rather about whether the choice of law is reasonably appropriate in the circumstances. And they make entirely fairly, that's the Law Commission make entirely fairly at paragraph 4.11, 1618, the forceful point, which I've made as well, in their language, it is, as they put it, doubtful whether the potential wrongdoer could be said to have any relevant expectations at all.
Those references again, Sir James.
So that was one was 4.13 on page 1619.
Yes.
And the doubtful whether a potential wrongdoer would have any reasonable expectations is the latter part of paragraph 4.11 on page 1618.
Thank you.
The core point being that that assessment takes place after the tort or edict has occurred and so on. Also, I did consider as part of this set of things about the factors, I did consider whether there was some interest or significance in the word significance. What's the meaning of significance in section 12? You'll recall that the comparative analysis that that section requires is a significance of the factors. And so the question is, what does that word add? What does it mean? And it's related to the set of points that I've just been dealing with, because the Court of Appeal appear to have approached that concept and that idea within section 12 on the basis that it imported the need to examine a broader range of circumstances, such as reasonable expectations of the parties. In other words, that it brought in, so judging the significance, brought in a wide-ranging set of kind of normative circumstances or normative considerations, if you will. And my submission is that Mr. Justice Lane's approach to this issue, at least implicitly, was the correct one. In essence, the significance of a factor is primarily focused on the significance of the particular element or event within the scheme of events that constitute the tort. So we're kind of back to that point about all the elements, but significance is linked to making an evaluative judgment about how important it is as an element within the scheme of elements that constitute the tort. It isn't an invitation to introduce broad normative ideas or ideas to do with reasonable expectations of the parties, if that makes sense as a submission. And that approach, keeping it tightly focused on the significance of the elements of the tort within the scheme where they're happening in different places, does, I submit, have the real merit of being able to provide a greater prospect of simplicity and certainty of analysis, and therefore a greater chance of promoting consistency of approach between different cases. And that, after all, was one of the core aims of the legislation, setting it up as it did, with the general rules and then the balancing and the weighting and all of that. But it's also more consistent with finding the seat of the tort by examining all of its elements and keeping tightly focused on them. And that was the point that was reinforced by the Supreme Court when they said, don't allow yourself to stray into things that, in that case, it would have been predicting issues at trial, but things that are extraneous, things that are to do with broader aspects. And I submit that when you start drifting into other territory outside the ingredients of the tort, it's all the more problematic, because there's no sensible way of judging against any objective standard what all of that involves and should involve, where you think about reasonable expectations and so on. And the final point in relation to this is, and the justification for the tighter focus, if there is a call for a broader moral, evaluative, judgmental aspects to be brought in at the Section 12 stage, then that would be problematic because unnecessary. And unnecessary because the legislation makes specific provision for public policy considerations to feed into the analysis as appropriate. But it does so under Section 14. So all of that, if appropriate and to the extent permitted by the statute and appropriate under the statutory regime, is already catered for.
And we're not dealing with any Section 14 argument?
We're not. For present purposes. We've dealt with that in our very long footnote, I think 12 in our case, if you wanted, but I'm not going to go back to that. I wanted to make three final points in response to the claimant's case on this aspect and I hope this may come a little bit more directly to some of the questions that my Lord Kitchen has been putting to me. First of them is that the claimant says he was ignorant and powerless about his presence in the 6 countries. And we say in relation to that it's of the very nature of the pleaded claim of intention to be detained in a black site, which is relied upon for misfeasance, conspiracy, false imprisonment, and the negligence claims. And there are claims made in that respect in all of the systems of foreign law that are relied upon. So it isn't, as it were, a deficit in terms of the Section 12 analysis. So the claims in relation to Thai law in that respect are in the amended points of claim, paras 66 and 68. Polish law.
So page number?
Page number 300, sorry, my Lord.
Yeah.
Polish law, points of claim 78B, page 302. Moroccan law, points of claim 88, page 306, and the reference there to black site detention and rendition aircraft. Lithuanian law, similar reference to black site detention at points of claim 98, page 308, and Afghan law with the references to arbitrary incommunicado detention, points of claim 106B to 106D, page 310. And all of those claims depend on the events occurring in the 6 countries, where on the claimant's case, his claims of unlawful detention, incommunicado detention, detention in black sites involve him being prevented from having any means to challenge his detention. That is, it's part and parcel of these detention-related claims that he was denied access to legal redress in the countries in which he was detained. He didn't, of course, on his case, choose or expect to be there, but that, I respectfully submit, does nothing to undermine or diminish the factors that actually connect, when the all-ingredients approach is adopted, the factors that connect the elements of the tort to those 6 countries. And it was essentially that which was the conclusion in answer to this claim, ignorant and powerless. That was the answer that was correctly given, I submit, by Mr. Justice Lane at paragraph 58. He says, second is
Is it 58 or 68?
58, my Lord, I'm sorry.
My fault.
He says as a linked point that he was deliberately kept outside the legal protection of the legal systems in those countries. And again, that's a point that's deployed, as the first point is, to seek to diminish the significance of the connections to the 6 countries. But I respectfully recommend, if I may, the analysis of Mr. Justice Lane in direct answer to this point at paragraphs 49 to 56 of his judgment in relation to that. True it is that this is an exceptional case and not easily categorised, but the various elements, for all the reasons I've submitted, that connect the torts to the 6 countries are indeed powerful for all the reasons I've given. And this fact does not undermine those connections, even if assumed to be true.
If there were inadequate legal protection for those within its geographical or jurisdictional boundaries, then you would accept that would be a factor under Section 12?
It could be a factor under Section 12 because it could feature within the concept of factor, which is referred to in Section 12. So I'm not denying that, but I'm not sure the claim here is that there were inadequate legal protections in those countries. It was simply that which I think is part of the answer that Mr. Justice Lane gave. It was that in practical terms, it appears that people thought that they wouldn't necessarily be enforced. And indeed, the pleading, which has already been produced against us in this respect, indicates that even the civil law of those countries has something to say about this sort of conduct. And we've seen from the Strasbourg judgments that it does too.
And then does it become a question of degree? If it is, if you would accept there is no, if it were the case that there was effectively a legal black hole in those jurisdictions. Would accept that would at least potentially be a relevant factor under Section 12.
I would, but my note of caution is that that isn't the position here.
Yes.
It doesn't appear to be the position here, even in relation to civil law, where claims have been pleaded which reflect under those civil law systems the wrongness of the conduct which is asserted. That was part of Mr. Justice Lane's answer, as I understand it, to this point, which is that in practical terms, what appears to have been done is to believe that they were, as it were, allies, and so there wouldn't, in practical terms, be recourse to that. But it isn't a problem of law; it's a problem of practicalities, or was a problem of practicalities.
And practicalities in your submission don't bear under Section 12.
They don't. They certainly wouldn't have the same degree of weight or the same.
That's not quite the question I'm asking you.
No.
But they would potentially be of weight under Section 12. Practicalities.
Well, my Lord, I'm very reluctant to take a stand that says you can exclude anything that is, as it were, related to the significance of the particular ingredients of the tort, because the word factor does appear to have been used deliberately in Section 12, and the VTB Supreme Court judgment indicates that's a relatively broad concept. So I don't wish to take a stand that says, in principle, never. And so it follows from that necessarily that the answer is it is a question of degree, and there may be a greater degree of significance if you genuinely do have an absence of legal protection. But my submission is you still have to look at the connecting factors.
I mean, insofar as the problem is one of enforcement rather than the law being there, I suppose it can be said that the enforcement can be by the United Kingdom court, because the claims brought here, the United Kingdom court will apply that law if it's the applicable law. So the problem of enforcement doesn't really seem to feature once you've got a case which is proceeding here.
Yes, although I suppose, in fairness to my learned friend's case, the argument that is being made, as I understand it, is that if you've got these connecting factors to those third countries, the significance of those factors should be diminished, because not merely was he not there voluntarily, as it were, but because he was being kept outside for practical or other reasons of that protective system.
Yes, thank
That's
you.
as I understand the argument, so I'm not sure that will be a complete answer to my learned friend's case. But as I say, I don't want to take a stand on the narrowness of the concept of factor. I made the submission it should be tightly focused on the ingredients of the offence. That's your call. That's your call.
Sorry, can I just press that point? I may be missing it, but we're dealing here with a case where the forum is England and Wales for the resolution of the dispute.
Yeah.
This court, in other words, has to look at what the applicable law that the English courts are going to apply to determine this dispute.
Yes.
Can it be of any relevance how, in any particular jurisdiction, that law, in relation to tort, how in practice it may or may not be applied in that jurisdiction, when all we're trying to apply is the law, not what the state of, we might have lots of settlements here, lots of settlements there in tort cases. That's got nothing to do, surely, with the applicable law. In other words, how in practice the law is enforced would seem to me completely irrelevant, but I may be missing the point.
Well, I don't wish to take a firm position against a point which looks favourable. My Lord, my submission is it's either irrelevant on that basis, or it is a factor of, at the very most, marginal importance, because this is the exercise which you're engaged in.
Yeah.
You say it falls within it is one of the potential factors in Section 12(1)(a).
Well, subject to the qualification I've just given to Lord Kitchen.
Yes,
on
that's right.
invitation.
Yep.
But certainly in a situation such as this, one can see there might be public policy arguments, well, there could be public policy arguments under Section 14 about the nature of a foreign law.
Yeah.
If, for example, it operated or was ex facie discriminatory or something of that kind, then you'd have a public policy concern. But that's already catered for under Section 14, and that's a limited and narrow point relating to that provision. I wanted as the third point just to deal briefly, or perhaps I don't know when my lord wishes to break. I've probably got 10 more minutes to go, so it may be better to.
Perhaps we'll hear that at 2 o'clock, Sir James. You're well within your time limit if you've only got.
I think when my own friend and I were discussing it today, we think there's a reasonable prospect that we might be finished today. That wouldn't be inconvenient. I'm sure it wouldn't.
Well, it's an important case, and you mustn't feel under any time pressures.
Thank you.